Hello and welcome to another very exciting episode of your number one legal talk show, The Courthouse. Always interesting, always exciting, full of knowledge and educative. We always share the law with you in plain, simple and entertaining language. I am Itsohan Olomu-Agbodo. But first, we'll go on a quick break. We'll be right back. Stay with us.
If we have to give you anything, then we have to give you everything. Love Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Love Plus Channel 465 on Star Times.
You're welcome back. If you just joined us, this is the Courthouse, and this week I have someone very interesting that I'll be introducing to you. But first, we're going to be talking about alternative dispute resolution, and it's in simple terms ADR, ADR for short, and it's all about resolving disputes, alternative dispute resolution. Instead of going to the courts, what do you do? Or is ADR a part of the judicial process? You get to find out from my very, very interesting guest this week. She's Nathaniel Esezobor-Odidika Esq. And I say she's very, very, very interesting because she's a friend of mine. So good to see you.
Same here, Aiti. You're looking bad.
Thank you. ADR, what is it about?
Okay. ADR, it's, like you rightly said at the beginning, alternative dispute resolution. For me, I see it as the opposite of litigation. It's one of the ways of resolving disputes among parties without having to resort to the courtrooms. And it actually it became popular because of the burdens, of bitterness that the courtrooms, the litigation lives in the mind of people. So that's how ADR came to be. And there are different types of ADR. We have mediation, we have arbitration, we have conciliation, neutral, But see, there are so many types, but the most popular one is basically mediation and arbitration. Now, people run away. Even when they have matters, how do they go about this? People are scared of going to court because, one, they're going to spend so much money hiring a lawyer, the court processes, time wasted, adjournments, and the rest of it. So, but with mediation, for instance, parties are directly involved. It's a party-driven process. Unlike the courtroom where you have the lawyers representing you, speaking on your behalf. But for mediation, you are the one speaking for yourself. You don't necessarily need your lawyer around. But you see, because like in Lagos State, for instance, the ADR center is in the court premises, but it's distinct, separate from the courtroom. But some people still feel a little bit uneasy without the presence of their lawyers. So some want their lawyers coming with them. But see, you don't need your lawyer to be there. You can actually walk in by yourself, and the courts can refer you to that, or parties decide on their own to come in. So for mediation, like I said, it's party-driven. Nobody, you don't need a lawyer, anybody speaking on your behalf. Like in mediation, you have the opportunity to speak for yourself. It's party-driven. You pour out your heart, you say the way it is, you vent the emotions. If we've seen institutions where people cry, some shout, some scream. After then you see them, after venting, they relax, and it's always been helpful. Now, mediation affords the party the opportunity to relate with the other person. At the beginning, sometimes parties don't get to see eye to eye, but by the time we've gone far into the mediation, you could see that the tension has calmed down because they come to understand. Now, mediation, your privacy is guaranteed. In the courtroom, people who are not even parties to your matter are in court, sitting down there.
Hearing the
public.
whole,
Some, in this era where we have social media, people are just, before you know it, it's flying
taking
around.
shots, putting it on social media straight up.
Do you understand? But in this situation, in mediation, if you're not a party to the mediation, you are not allowed in.
Okay. Quite interesting. You've talked about basically you've focused on the benefits, and it's quite interesting. You talked about mediation and arbitration being two major types of the most common types of
so many
ADR.
others,
Yes. So you focus majorly on mediation. Is arbitration the same thing?
Like I said before, the other major type of ADR we have is arbitration. If a lot of people seem to go with it, they are not so used to mediation because they don't know the benefits of mediation. For arbitration is, I would say, it's similar to, it's adversarial, in system, similar to the courtroom setting. But the difference between it and the courtroom is that in arbitration, the parties have the right to appoint who the arbitrator will be. The arbitrator is a neutral individual. Yes. Okay. But you see, in arbitration, evidence is called in to determine facts or law or procedures. Evidence, you call for evidence and all that to just resolve it. But it's less formal in some way as compared to the court setting. Yes, and then the parties arrive at their own decision. And they have the right to appoint the arbitrator they want, unlike in the court setting. In some cases, the court can appoint the arbitrator for them, but most of arbitrators, the parties are the ones who have a say in who mediates in their matter. So it's less expensive when you compare it to litigation. And then usually the time frame too is less compared. You don't get to have so many adjournments like you do. Even if you have adjournments, just little. Maybe about within 45 days or so, you get to hear the decision, all the decision, and it's binding. So whatever, since you have appointed the arbitrator by yourself, whatever decision he arrives at is binding on the parties. If it's binding, you may not have the opportunity to appeal it. And in some cases, you can appeal it. Unlike mediation. In mediation, the parties have to agree to it. You try to, I forgot to mention that the mediator is a neutral third party that helps to facilitate communication between the parties to come to an amicable resolution. Okay. You don't.
That's also in mediation.
In mediation,
a neutral third
yes.
Party.
You're not compelling the person. The mediator is just, like an umpire, not interfering, but doing reality checks. So it's okay, fine, I understand this is this. It's not in the position of the mediator to tell you what to do or to help you arrive at your decision. It's what you do by yourself. But in arbitration, the arbitrator tells you at the end of the day, arrives at the decision, having considered the evidence, the facts before it and all that. In mediation, you don't have all those, where you start looking for evidence, facts, and all that. Because once you're doing that, it's as if you're going back to
the courtroom.
Yes, and that was not the reason why mediation was put in place in the first place, and just bringing that up.
Okay, so now we also have, we hear about arbitration, the court for arbitration for sports and things like that, and we also hear that in some agreements, arbitration is added as a clause to an agreement. So is it compulsory these days to have arbitration clauses or ADR clauses in agreements?
Well, it's not compulsory, but it's always necessary that parties have that couched in the agreement.
Okay.
Because when you look at the cost of litigation, the time wasted, the relationship that is destroyed, because litigation at the end of the day, in litigation you have you have a winner and a loser. And if I lose out to you, I don't see any reason why we should continue being friends. Do you understand? So that bitterness is there, is already created. So in order to forestall that and save time and even save the cause of stress, a lot of people are encouraged to have that cautionary agreement that in case of any dispute or breach arising from this agreement, let's resort to arbitration or ADR. So some go ahead to mention the particular type they want. Others leave it open. And that's okay, fine. And when it fails, we can, investigate. So it depends on the parties. It's always good because by the time you do that, you first look inward. It's when you can't come to an agreement, then if you want to resort to court, because it's not all matters that come for that is ripe for, that is that can be mediated upon. There's some technicalities that the courts need to resolve. At that point in time, mediation might not really, fine, you may just save that relationship, but those technicalities have to be resolved before the parties can really go ahead to forge ahead with their relationship. So it's always best for parties to have it couched in the agreement. Yes.
Okay, quite interesting. We've been listening to a very interesting speaker. I like to maintain that, Nathaniel Esezobor-Odidika Esq, talking about alternative dispute resolution mechanisms. And she mentioned two major types of ADR processes, mediation and arbitration. And she's also said it's very, very important. It's encouraged that you have couched in your agreement these days a clause saying that you can resort to ADR in case of any dispute. If a dispute were to arise, resort to ADR because it's actually very fast and it will help you to maintain your relationship at the end of the day. Yes. But we have a report for you on ADR process and our legal nuggets. We'll be right back.
Alternative dispute resolution, also known as ADR, is a procedure for settling disputes without litigation, such as arbitration, mediation, or negotiation. ADR procedures are usually less costly and more expeditious. They are increasingly being utilized in disputes that would otherwise result in litigation, including high-profile labor cases, dispute actions, and personal injury claims. One of the primary reasons parties may prefer ADR proceedings is that, unlike adversarial litigation, ADR procedures are often collaborative and allow the parties to understand each other's positions. ADR also allows the parties to come up with more creative solutions that a court may not be legally allowed to impose. Arbitration is a process similar to an informal trial where an impartial third party hears each side of the dispute and issues a decision, and the decision may be binding or non-binding. An arbitrator is an impartial person given a power to resolve a dispute by hearing each side and coming to a decision. Mediation is a collaborative process where a mediator works with the parties to come to a mutually agreeable solution. Mediation is usually non-binding. Even though alternative dispute resolution is intended to reduce the cost, stress, and formality associated with going to court, many parties still hire attorneys to represent them at ADR proceedings. They also seek out pre-proceeding consultations about possible solutions or strategy. Just as with any legal dispute, you should hire an attorney with experience in your particular legal issue, who also is familiar with the collaborative process of ADR.
Welcome back. This is still the courthouse, and we're talking this week about alternative dispute resolution mechanisms, ADR. And I'm still having in the courthouse this week Nathaniel Esezobor-Odidika Esq, who's been talking to us about some types of ADR processes, and she's actually explained them and giving out the benefits. For instance, like mediation, she said you pour out your heart and time saving
Yes,
as well. Okay, now we know that at the end of the day we get to hear about terms of settlement, and in some cases these terms of settlements are taken to the courts to be stamped as judgments of the courts. Yes. Tell us a bit about terms of settlement.
Yes, in terms of settlement, actually the agreements that the parties have reached, and then once they reach those agreements, they are reduced into writing, and we call them terms of settlement. Okay. Now, once parties have arrived at those terms and they are reduced into writing, the parties sign, it becomes a consent judgment. Okay. Because on the form, you have the parties' signature where the parties are supposed to sign. Yeah. And then you have the ADR judge also ascend into, because people have expressed some fears that, okay, it's not, you know, enforceable and all that, especially with mediation. People are not that so. Some people feel more comfortable with arbitration as against mediation. They don't know that there are a lot of benefits attached to mediation. Now, for those who feel that with mediation you can have the terms enforced, it's a big lie. You can have those terms enforced. The moment that has been done, take it to court. It's, like you said, stamped and entered as a consent judgment. And and there's always a default clause where it says that when the party does not honor the agreement reached, then the other party is at liberty to enforce those agreements against them. We've had matters, that agreements, terms of settlements, that parties have enforced against the defaulting party. We have people. And then for mediation, there's this affidavit of no contest. That, you know, some people might just, after agreeing to settlement, they turn around to go and say, okay, no.
No, I didn't agree to term 2 and the rest.
So once that's, you know, that's affidavit of no contest prevents the party who feels he or she is at the receiving end from going to contest it. Because, yes. And then one good thing about mediation is that you can appeal the decisions. Unlike arbitration, you can, in some cases, appeal against the decision of the arbitrator, but once it's a binding arbitration decision, you cannot appeal against it. But for mediation, you can't appeal because there's a confidentiality form you feel that you do not take whatever is discussed within the mediation, you know, setting session outside. Once you sign that form, you're bound by those rules there. You can't take it out. You can't turn around tomorrow and all that. If you do that, it is serious breach and it's actionable. So that confidentiality is maintained all through. Nobody can, you know, contest because it's believed that decisions that are reached by parties were voluntary. That's why the process is a voluntary process. Party-driven. You know, you came to those agreements, you were taken through those processes, introduced to it, you went through, stated your matter, and then amicably, you on your own resolved and came to those terms. And before you sign, like at the Lagos Multi-Door Courthouse, you have to go through those terms all over again, and then be sure that what you agreed is what was reduced into writing. Once you're satisfied, you sign them. And once you sign them, you can't turn around to say, oh, I was, you know, that's why the mediator is not in any way interfering in your decision. It's a voluntary arrival, you know.
Okay.
Yes.
I like that because you cannot turn around suddenly and say, no, I wasn't aware that term 2 was included or term 3 was included. It's going to be, I think it's actually very good because when you stop deceits, kind of.
Yes.
You have to make the process as transparent and honest as possible. Now, we also mentioned that it's faster.
Yes.
It's supposed to be faster than normal litigation in courts. So how fast really is ADR?
ADR is very fast, and I would recommend ADR to anybody, anytime, any day. We've had matters resolved within, you know, hours, some within a day, some may take longer process, some within a week is resolved. The good thing about ADR is, you know, it becomes faster when the parties are willing to settle. We encourage people, especially during mediation sessions, that you should be able to shift ground. You don't come to mediation holding on to your ground, it must be my way or never. That's what happens in litigation, in the courtroom. But here, parties are saying, okay, be realistic. You're appealing to their conscience. You be considerate, put yourself in the other person's position. What would you do in this situation? So you look at it, you're able to shift ground. Now, people believe that mediation is a win-win. Yeah, it's a win-win. It doesn't mean you don't lose out some because you're shifting ground, you're letting go some things. You're compromising, yes. So once you compromise, okay, let's go at one end. Because what you're looking at is that relationship being maintained after. Because tomorrow, just someone may fall in love with my daughter.
Oh, yeah.
And then, you know, and you say, okay, because, you know, that bitterness, never will not allow it to happen. But if it's to be mediation, because parties have reconciled, they shake hands again and all that, you can still carry on with your relationship. So basically, people need to understand. The public don't know much about mediation. They feel, oh, yeah, it's too much, it's different, it's faster. People, I've had to sit in mediation. I'm a mediator, And I've had to resolve, I have about 10 cases that I've been able to resolve in one day, you know. And that was because what even helped a great deal, but that the parties were open, they had an open mind, and they were willing to shift ground. And they were looking at, okay, like one man said, I really, you know, love this person, I love our relationship, I would like to maintain it beyond this process. So, you know, and that willingness was what made them resolve that matter within a couple of hours. One of the fastest I had resolved was within an hour, 30 minutes. And I was like, wow.
That was fast.
Yes, an hour, 30 minutes. In fact, that was my very first case. And that, you know, that gave me that courage like this can actually work. So people need to understand, the public need to know that mediation is, ADR is a very wonderful process. It's fast, really fast, I'm telling you. When you compare it with the adjournment and all that.
Compared with the adjournments, really. And like you said, at the end of the day, the relationships can be maintained,
yes.
Unlike the bitterness that lingers in litigation.
Yes, definitely.
But if the other party is not willing, and this is mediation now, for instance, and we had issues, one party is going to the multi-docker courthouse, using the Lagos multi-docker courthouse as an example, and the other party is not willing. How do I ensure that the other party comes along with me?
Yeah, that's a very interesting question. You see, for mediation, it can't go on without one of the parties, yes, you know, expressing the willingness. For mediation, a party must submit himself to mediation. So you can't compel someone to come for mediation. Like, you know, I said at the beginning part that for mediation or ADR, some are court referred, some are walk-ins, some are screened. So parties on their own can walk into the center and say, I want to have this, please can you invite this person over? So what the Lagos Multi-Court does have to is to invite the party. Please, there's a matter pending here before, can you please come? Some come, if they don't come, they don't, you know, compel them to. But when it's court referred, the court, you know, refers the parties to mediation, you must come. And then if you don't, that is because every time there's a court-referred matter, there's a report sent back to the court before the next adjourned date in court. So the ADR judge will always look at it. And in some cases, the party can be, you know, in fact, you subpoena the person. You have to attend mediation. Yes.
Quite interesting. It's been a very, very interesting discourse. ADR, alternative dispute resolution, is a sure way to go to resolve your disputes. And you know you always need to get a lawyer to advise you on things like that. And that's why Nathaniel Esezobor-Odidika Esq is here. She's a mediator, and she talks extensively about the benefits of ADR. Your relationship will be maintained. It's less time-consuming and less aggressive. It's cheaper than litigation.
Voluntary, it's confidential.
It's confidential as well. You won't have your matters referred to social media and things like that. So I didn't tell you about this earlier. There's another segment. It's called the Bar Book. And inside the Bar Book, we have Latin maxims and their meanings. So I'm putting you on the spot. Okay, let me help you out. Let me start with mine. You mentioned the fact that when people have arrived at terms of settlement, they cannot, there's an affidavit of no contest, where you cannot say, this is not my deed.
Yes.
So this week I'm going to do non-ex factum. And non-ex factum means not my deed. So that's my Latin maxim for the week.
Okay.
I'm waiting for yours.
You're really putting me on the spot. Okay. I want to use this particular, Oteram pater. That's my Latin maxim for the week. It says, everybody has a right to fair hearing. You must hear every, always hear, because when you do that, you get to have, you appreciate the whole process. So bringing that to ADR, you have to hear both parties. As a mediator, it gives you an informed decision and know what to say to the parties, what to, you know, the reality checks to, you know, you can do with them during bargaining phase and all that. And then for arbitration, it helps the arbitrator to know what decision to arrive at, after looking at the evidence and facts and everything that's brought before him. So,
quite interesting.
Thank you.
Well, it was quite nice seeing you being set up like that. But we have some more Latin magazine for you in our Bar Book segment. You're welcome back. It was a very interesting discussion we had with Nathaniel Esezobor-Odidika Esq talking about ADR mechanisms, ADR processes, and she focused majorly on mediation, arbitration. We talked about terms of settlement and a whole lot. Quite interesting, and I must say thank you for making out time to be on the courthouse this
Thank you
week.
very much.
Okay,
I look forward to some other time.
Yes, we'll look forward to seeing you too. So I would like you to log on to our website if you have comments for us or you want to check out any updates. You can log on to www.loverplus.tv and you can send comments to numbers that are showing on your screen. And we'd like to have questions from you. Our legal experts are waiting to provide answers to your questions. You can send your email to info@loverplus.org. I'm Itohan Olomu-Agbodo, and I say, don't just get mad, go get a lawyer. Bye for now.